Hello friends, welcome back to the series of lecture. This is the 54th lecture of this series of Indian Evidence Act. In the previous lecture we had looked upon the 103 and we also done earlier 104 also. So let's start with 105. When a person is accused of any offense. When a person is accused of any offense, the burden of proving the existence of circumstances bringing the case within any of the general exceptions in the Indian Penal Code or within any special exception or proviso contained in any other part of the same code or in any law defining the offense is upon him, and the court shall presume the absence of such circumstances. Now you see section 105 in particular is about IPC. There are certain general exceptions in the IPC. You may be aware of that. Chapter 4 General Exception IPC from 76 to 106. Act done by child below 7 years, unsound, etc., unsound mind person, etc. Plus there may be certain specific exceptions. For example, section 300 you have got 5 exceptions. Then there may be certain provisos also. For example, in section 499 they have got 10 provisos. So in that way there may be any proviso or exception to any section or the general exception. What they are talking about is if an accused is being tried for any offense and he claims the application of any of these exceptions, general exception or any of these proviso, general exception or either of these provisos, etc., then upon whom the burden of proof will lie. So it's obvious कि अगर 105 नहीं भी होता तो 103 याद करो आप. 103 clearly says that the person who alleges the fact, the burden will lie upon him. If I am the accused and if I claim that I am unsound at the time of committing the offense, so burden of proving my unsoundness, the burden of proving my unsoundness will lie upon me. So it is a general declaration which is given in 103 also. So if we read it again, when a person is accused of any offense, the burden of proving the existence of any circumstances. Circumstances means what? Facts. The facts. The burden of proving the facts, that is the circumstances, bringing the case within any of the general exception, bringing the case within any of the general exception or within any special exception. स्पेशल एक्सेप्शन जैसे सेक्शन 300 का स्पेशल एक्सेप्शन, 5 exceptions are there, or proviso contained in any other part of the same code or in any law defining the offense is upon him, and the court shall presume the absence of such circumstances. Is upon him means what? Is upon the accused. And then in the end they are saying that the court shall presume that such circumstances were absent. What is meant by that last part? They are saying shall presume. The court shall presume. It is mandatory upon the court and it is revertible, no doubts. And as we know that we have discussed shall presume earlier, it is mandatory upon the court to presume such a fact that there is no such circumstance. मान लो A is an accused who is tried for murder. Now the court shall presume that there was no such circumstance which bring this case under any of these exceptions, which will bring this case in any of these exceptions. So at the defense stage, जब defense trial का stage आएगा, at the defense stage, it is A who raised the pleading that there was any of these exceptions applicable. जब defense का stage आएगा तो A raise करेगा pleading that any of these exception is applicable. Now the court shall presume means what? The court will not itself raise the point that there was any general exception or any other exception applicable or any other exception applicable, and the word used shall means the court has to presume, and therefore the burden of proof upon the defense will be what? Strict. The burden of proof upon the defense will be strict, to revert that presumption. तो यहाँ पर सिर्फ अपना जनरल एक्सेप्शन प्रूफ नहीं कर रहा, यहाँ पर आपको सिर्फ अपना जनरल एक्सेप्शन ही प्रूफ नहीं करना, बल्कि आपको जो कोर्ट ने प्रिज्यूम कर रखा है कि जनरल एक्सेप्शन अप्लाई नहीं होगा, उसको रिवर्ट भी करना है. So slightly strict burden of proof will lie upon the defense. Slightly strict burden of proof will lie upon defense. So write down upon it. Section 105 declares. Section 105 declares what is implicit in Section 103. That is, the accused who claims that any of the exception applies upon him, the burden of proving of the exception would lie upon the accused. The court as per last part of section 105 would raise the presumption that there is no such exception applicable, and since it is shall presume, the court has to raise such presumption. Thus the burden of rebuttal would lie upon the accused and it will be a strict burden. अब strict का मतलब ये नहीं है कि it is very very strict. It means you prove the circumstances. वो preponderance of probabilities का रूल लगेगा. वो अब आपने circumstances prove कर दिए, तो आपने अगर circumstances prove कर दिए and the court finds that the exception applies, then the court will give you the benefit. So it does not mean that the court would be immensely strict. इतना भी strict नहीं रहेगा कि आप prove ही ना कर पाओ. So if you prove that there is no such circumstance, if you prove that there are circumstances, if you prove the basic circumstances, then the court can give you the benefit of the exception. Now when you read the IPC, this section 105 is very important while discussing the general exceptions or any exception or provisos. So you should remember 105 for that purpose. See the illustration. A accused of murder alleges that by reason of unsoundness of mind he did not know the nature of the act. So the court will presume that he was not unsound. Court तो यही presume करेगा कि he was not unsound. So the burden of proving he was unsound lies upon A. So the burden of proof is on A. Then illustration B. A accused of murder alleges that by grave and sudden provocation he was deprived of the power of self-control. This section 300 का exception number 1. So the burden of proof lies upon A. Now see, section 325 of the IPC provides that whoever, except in the case provided by section 335, voluntarily causes grievous hurt shall be subject to certain punishments. A is charged with voluntarily causing grievous hurt under section 325. The burden of proving the circumstances bringing the case under section 335 lies on A. Section 335 में भी वही है, grave and sudden provocation. कि अगर आपने किसी को grievous hurt या grave and sudden provocation ये किया है तो punishment कम हो जाएगा. And 335 में you are charged and tried and presumption is there that there is no grave and sudden provocation. So the burden lies upon the accused to prove that there was grave and sudden provocation. Okay, now let's get into section 106. 106 is saying, when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. अब देखो यहाँ पर जो लिखा है, that is normally implicit in section 103. But by way of caution it may be, by way of declaration, they want to make it especially declared. Otherwise, what is given here, that is already there in 103. Now suppose there is a fact which is personally within my knowledge. So who will prove that fact? So obviously I have the knowledge of it. So I will prove the fact. When any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. Illustration देख लो. When a person does an act with some intention other than that which the character and circumstances of the act suggest, the burden of proving that intention is upon him. B. A is charged with traveling on a railway without a ticket. The burden of proving that he had a ticket is on him. अब ए विदाउट टिकट पकड़ा गया है. अब ए का कहना है कि मैंने तो टिकट खरीदा था पर किसी ने मान लो मेरे पॉकेट मार लिया. वो कह रहा है कि मेरी पॉकेट मार ली. Someone pick my pocket. Now he knows that I have purchased the ticket. So who will prove? He will prove. The burden of proving that he has a ticket is on him. Let's take an example. Suppose this is a road. This is a road and this is the divider of the road. And this is the other side of the road. Now suppose B is standing here on the road and A is standing on the footpath. Now there is a truck coming from this side at a high speed. Now A pushes B. In order to save him, A pushes B. अब B थोड़ा हल्का फुल्का था, पुश करने के बाद जंप करके इधर पहुंच गया. So when A pushed B, B went across and reached to the other side of the road. And from here, there was a bus coming. And this bus ran over B. B मर गया बेचारा. अब in order to save him from the truck, A pushed him, but he was light-weighted person. So he jumped across and went to the other side. And the bus ran over him and he got dead. Now upon A, the charge of murder is there, that he deliberately pushed B to be killed by the bus. But within his heart, A knows that I was doing social service. उसको तो यही पता है कि that I was doing social service. My intention was not to kill him. My intention was to save him. Where the circumstances are suggesting that his intention is to kill him. Now who is having the burden of proof that my intention is to save him? He has that intention. So that is what they are saying. So had it not there in 106, had it not been in is there in 106, it would fall under 103. Now he will assert that I have the good intention to save his life. So the fact that he was asserting the fact, so the burden of proof will lie upon him. So if he had the knowledge that I was acting with good intention, then let him prove it. अब suppose दो students साथ में बैठे हैं, you have taken, one has taken the bare act or copy of the other student and there is charge of theft upon that student. Within his heart, he know that by mistake it was taken. In his heart, he know that by mistake he took it. So in that case, that knowledge by mistake or in good faith that you took it. Now suppose the other student, the class was over and then he left the copy. You left the class after that person. You thought that if I will not take this copy, then he would miss it. So I will give him tomorrow. So therefore, to protect that copy or your act, you took it with the intention that tomorrow you will return it back. So here your knowledge that you are took it in the good intention is with him. So he is having the burden of proof to prove it. So that is about 106, section 106. मतलब कोई भी अगर आप काम करते हो उसका इंटेंशन या नॉलेज, उसका स्पेसिफिक इंटेंशन या नॉलेज आपको पता है कि मैं गुड फेथ में एक्ट कर रहा हूँ, फिर भी सर्कमस्टेंसेस सजेस्ट कर रहे हैं दैट यू हैड द बैड इंटेंशन. सो प्रूविंग योर गुड फेथ एलिमेंट, प्रूविंग योर इनोसेंसी, द बर्डन लाइज अपॉन यू. सो दैट इज अबाउट 106. अब 107 ऑनवर्ड्स, अभी तक तो इट वाज अबाउट बर्डन ऑफ प्रूफ, but 107 onwards it is about presumptions. 106 तक तो it was about burden of proof, but 107 onwards it is about presumptions. वैसे तो 105 में भी you also have the presumption that shall presume. So 107 till 114a, but some of the sections we had already covered, like 112, that was major discussion we have already done. Important area तो पहले cover कर लिए हैं. Important तो ये भी हैं बाकी के, but more detailed area we have covered. 113 you have to do your own, that is also about conclusive proof. 114 I have discussed. All the illustration we have not done, but main illustration we have done, वो आप कर लीजिएगा. 113A is related to rape and consent that we would discuss in IPC. Sorry, 113 is related to rape and consent. We would discuss it with IPC. And 113A and B related to 113A and B relate to abatement to suicide and dowry that is also we discuss with IPC. What remains is 107 till 111. So these 4-5 sections we have here to discuss. Now please take out 107. When the question is whether a man is alive or dead, and it is shown that he was alive within 30 years, the burden of proving that he is dead is on the person who affirms it. अब मानो कि the question in the suit or the proceeding is that A is alive or dead. Now X, one of the party who is interested, he is interested in proving that he is alive, and Y, the opposite party, is interested in proving that A is dead. Now what X does is he give evidence that in last 30 years A was alive. पिछले 30 साल में कभी भी he gave the evidence that A was alive. Then thereupon the burden of proving that A is dead will lie upon whom? Y, the opposite party. So means generally they are declaring a policy that if a person is found to be alive today, then in next 30 years, if a suit is filed and in that a question is that whether the person was alive or not, then he is deemed to be alive. So that is the kind of presumption कि अगर पिछले 30 साल में एक व्यक्ति जिंदा था तो आज भी जिंदा होगा. अब ये कैसे लगेगा, दैट इज डिफरेंट क्वेश्चन बट इट इज लॉ. अब मान लो आज से 29 साल पहले एक व्यक्ति 104 साल का था, तो वहां पर भी आप ये प्रिज्यूम कर रहे हो कि आज 29 साल भी वो व्यक्ति जिंदा होगा. तो मीन्स अब 129 प्लस 104 133, तो 133 साल तक वो व्यक्ति जिंदा है. दैट काइंड ऑफ प्रिजम्पशन इज देयर, बट अगेन दैट इज इन रेयर केस. अदरवाइज नॉर्मली if a person is found alive today, then it is presumption that he will be found alive till next 30 years. He is believed to be alive till next 30 years. And the party who says that he is dead, the burden of proving will lie upon that person. अब सेक्शन 107 को और 108 को साथ साथ पढ़ते हैं. 108 is the proviso to 107. Provided that when the question is whether a man is alive or dead, and it is proved that he has not been heard for 7 years, he has not been heard from 7 years by those who would naturally have heard of him. If he had been alive, the burden of proving that he is alive is shifted to the person who affirms it. Now देखो, अगर 7 साल से आपके बारे में अगर किसी को पता नहीं है कि आप कहाँ हैं, तो वहां पर माना जाएगा कि आप मर चुके हैं. तो अब जो चाहता है कि वो प्रूव करे कि लाइव है, तो उसके ऊपर बर्डन होगा कि वो प्रूव करे कि ये अलाइव है. अब सपोज टुडे इज द क्वेश्चन वेदर ए इज अलाइव और नॉट. हियर इट इज द डेट एंड फ्रॉम हियर दिस इज 30 years. अब X is interested in proving the case that A is alive, and Y is interested in proving that A is dead, and the suit is between X and Y. अब X proves that from today 28 years back this A was alive. तो सेक्शन 107 लग जाएगा कि नहीं. उसने प्रूव कर दिया कि आज से 28-29 साल पहले ये व्यक्ति जिंदा था, तो सेक्शन 107 applies. अब the burden of proving that he is dead lies upon whom? It will lie upon Y. Y proves that from today for last 7 years, any person would have known as to where A is. Means there is no person who is aware of, who is having knowledge about whereabouts of A from last 7 years. मतलब उसका कोई भी दोस्त या रिश्तेदार किसी को भी नहीं पता है that where this A is. अब बताइए प्रिजम्पशन क्या होगा, that A is dead. अब now initially X proves that A is alive 28 years back. Now the burden shifted upon Y to prove that he is dead. Y proves that from last 7 years his whereabouts is not known. So now the burden will shift upon whom? Upon X. So now X has to prove that this person is alive. तो ये समझ में आया? 107 आप फिर से पढ़ लो. When the question is whether a man is alive or dead, when the question is whether a man is alive or dead, and it is shown that he was alive within 30 years, the burden of proving that he is dead is on the person who affirms it. Now in my example, the suit is in between X and Y, and the question is whether A is alive or dead. Now X proves that from today 28 years back, A was alive. So his burden is fulfilled. Now A is deemed to be alive. Now the burden will shift upon Y, that he proves that A is dead. Y not able to prove directly that A is dead, but Y is able to prove that as from to last 7 years, the whereabouts of A is not known by any of the person who has naturally have been known about his whereabouts. And therefore the section 108 will apply, and now the presumption is that the A is dead. Now the burden lies upon the X to prove that he is alive. X को एविडेंस देना पड़ेगा कि पिछले 7 साल में वो कभी जिंदा था. अगर नहीं था, नहीं प्रूव कर पाता है, तो प्रिजम्पशन होगा कि ये पर्सन इज डेड, दिस पर्सन इज डेड. सो इज दैट फाइन? नाउ 109, section 109. When the question is whether persons are partners, when the question is whether persons are partners, landlord and tenant, or principal and agent, and it has been shown that they have been acting as such, the burden of proving that they do not stand or have ceased to stand to each other in those relationships respectively is on the person who affirms it. Now let's take an example. Suppose A and B are the principal and agent. A is principal and B is the agent. The relationship between them is principal-agent relationship. B is working for A, so A is the principal and B is the agent. Now B is working in the office and salary was paid by the A. Salary is paid by the A to B. And B takes all the commands of A, whatever he tells him. Whatever A tells B to do, he do that. So that is sufficient enough to prove the principal-agent relationship. Suppose A and B are in a suit. A says that B is my agent and B says that I am not A's agent. A proves the circumstances by which it can be proved that there is a agent-principal relationship. अब मान लो A और B के बीच कोई formal contract नहीं है. So A is not having a document proving that B is his agent, but A proves that he is drawing salary from him. He is taking commands from A. The office is A's office. A pays the rent of the office and so forth. So A proved the circumstances which suggest that B is his agent. Now B says that he is not his agent. So burden of proving of that B is not his agent lies upon whom? Upon B. Similarly, take example of landlord and tenant. Suppose A and B are in tenant and landlord relationship. Suppose L is the landlord and T is the tenant. And now tomorrow landlord says, L says that T is not my tenant. L says that T is not my tenant. Suppose today L gave the notice to vacate the premises to T. Notice given by L to T to vacate the premises. And now suppose T says that I am not the tenant of you. So sorry, T says that I am your tenant and tenant है तो फिर रेंट एक्ट लगेगा और आप मुझे इस तरीके से नहीं हटा सकते. लेकिन अगर मैं लाइसेंसी हूँ तो आप मुझे कभी भी हटा सकते हो. अब लैंडलॉर्ड का कहना है कि ही इज अ लाइसेंसी, टी इज लाइसेंसी, और टेनेंट का कहना है दैट आई एम टेनेंट and he cannot vacate like that. So now there is suit between landlord and tenant. Now landlord alleges that T is the licensee and therefore he should vacate the premises. And T alleges that L and T means both they are landlord and tenant, and therefore without any personal necessity he cannot tell L cannot tell T to vacate the premises. अब L और T के बीच में dispute हो गया. अब L is saying that you are not my tenant. T is not my tenant. अब suppose T prove the circumstances. Suppose there is no rent agreement between L and T. Now there you see, if T proves the circumstances that he is enjoying this premises since 5 years, and he also proves that he is paying the rent through his bank statement, that he is paying him regular rent, and he is also paying the service tax, and so forth. Is it not the suggesting circumstances that T is the tenant? अब द बर्डन ऑफ प्रूविंग दैट टी इज नॉट द टेनेंट वो किसके ऊपर होगा? लैंडलॉर्ड एल के ऊपर. दैट इज व्हाट सेक्शन 109 सेइंग. रीड सेक्शन 109 अगेन. व्हेन द क्वेश्चन इज वेदर persons are partners, landlord and tenants, or principal and agent, and it has been shown that they have been acting as such, the burden of proving that they do not stand or they have ceased to stand to each other in those relationships respectively is on the person who affirms it. मतलब जो कहता है कि मैं इसका एजेंट था ही नहीं, या फिर एजेंट था पर अब मैं इसका एजेंट नहीं रह गया, तो वो बर्डन किसके ऊपर होगा? जो ऐसा कह रहा है, द पर्सन हु सेज. ओके, so now section 110, read. When the question is whether any person is owner of anything of which he is shown to be in possession, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. So this is जो आप jurisprudence में कहते हो ना, possession is 9 points of law of ownership. Possession is 9 points of law of ownership. Means possession अगर है तो आपको owner माना जाएगा. सिर्फ एक पॉइंट बाकी है, दैट इज टाइटल. तो अगर टाइटल ना हो, सिर्फ पोजेशन है, तो आपके फेवर में टिल्ट होगा हमेशा कि आप ही ओनर हो, तब तक जब तक कि कोई और अपना टाइटल प्रूव ना कर दे. अब सपोज टुडे आई विल बी इन पोजेशन ऑफ दिस प्रेमाइसेस, आई विल बी इन पोजेशन ऑफ दिस प्रेमाइसेस, so I will be presumed to be the owner of this premises, and if any other person says that I am not the owner, then the burden lies upon him to prove that I am not the owner. Suppose if I am in the possession of my house, then obviously the law will be tilted towards me to presume that I am the owner of my house. Now if someone says that no house belongs to him, then the burden lies upon him to prove that I am not the owner. तो ये तो कॉमन सेंस से सबको पता है कि दैट पोजेशन इज रेस्पेक्टेड बाय लॉ. जिसका भी पोजेशन है लॉ मानेगा कि पोजेशन उसका है. अगर अपोजिट पार्टी कहता है कि वो ओनर नहीं है, पोजेसर ओनर नहीं है, तो बर्डन अपोजिट पार्टी के ऊपर होगा कि वो प्रूव करे कि पोजेसर ओनर नहीं है. तो आप प्रूव कर दो कि मैं ओनर नहीं हूँ तो दूसरा वाला ओनर हो जाएगा. अब लेट्स टेक एन एग्जांपल कि ए ने कोई प्रॉपर्टी बेचनी चाहिए. देयर इज अ पीस ऑफ लैंड ऑफ ए. अब नाउ ए सोल्ड इट टू बी ऑल्सो एंड ए सोल्ड इट टू सी ऑल्सो, सेम डे की ऑन द सेम डे. द डॉक्यूमेंट्स आर completed on the same date. अब now the question arose upon of the ownership. अब मान लो बी ने उसमें पोजेशन ले लिया, उसमें अपना कुछ बना लिया, रहने लगा उधर पीस ऑफ लैंड में, सी पे पोजेशन नहीं है. अब डॉक्यूमेंट सेम डे के, देन हु वुड बी द कोर्ट विल बी टिल्टेड इन हुज फेवर? बी's फेवर, until unless it is proved that B taken that by fraud. अब ए के ऊपर फ्रॉड की प्रोसीडिंग्स होगी, दैट इज अ डिफरेंट थिंग, बट वी आर टॉकिंग अबाउट द बिटवीन बी एंड सी, बिकॉज बी और सी में, अब बी पोजेशन में तो कब्जा खाली कराने की जिम्मेदारी किसकी है? सी की. सो सी विल गो फॉर वैकेटिंग फॉर फ्रॉम premises. So law will always tilted in favor of B, and he also having the document. So means जिसका भी possession है, suppose upon a property A is in possession, then obviously the court will presume that he is the owner. And if B says that he is not the owner, then the burden of proof lie upon B to prove that A is not the owner. That you can prove by proving the title of A be defective, or you can prove by proving that I have got the perfect title to the property. So possession is considered to be the 9 points of law regarding ownership. So 10 पॉइंट्स में से अगर possession आपके पास है तो 9 पॉइंट्स आपके फेवर में है. एक पॉइंट दैट इज टाइटल, वो बस डिसाइड होना है. तो 10 में से 9 पॉइंट्स आपके फेवर में रहेंगे अगर आपके पास पोजेशन है. एक पॉइंट जो टाइटल है उसको डिसाइड करना रह जाएगा. सो दैट इज व्हाई इट इज कॉल्ड 9 पॉइंट्स ऑफ लॉ. एक बार और पढ़ लो. When the question is whether any person is owner of anything of which he is shown to be in possession, the burden of proving that he is not the owner is on the person who affirms that he is not the owner, so that they can prove by proving his own title. So that he can prove by proving his own title. Write down a sentence upon this section. This talks about presumption of ownership in favor of possessor, in favor of the possessor. This talks about presumption of ownership in favor of the possessor. Now see section 111. सेक्शन 111 को आप थोड़ा सा कॉन्ट्रैक्ट से रिलेट कर सकते हो. Read it. Where there is a question as to the good faith of a transaction between parties, one of whom stands to the other in a position of active confidence. In a position of active confidence, the burden of proving the good faith of the transaction is on the party who is in a position of active confidence. Now, what is meant by active confidence? What is meant by active confidence? इसी को आप कहते हो fiduciary relationship. It is about the relationship between two persons like teacher and student. Teacher is in the possession of in influencing the will of the student. Similarly, guru, adhyatmic guru is in the position of influence the will of his disciples. A father has the position of to influence the will of his son or daughter. Similarly, a lawyer is in the position of to influence his client. Similarly, an employer is in position to influence the will of his employee. So ये जो relationships हैं, in which the one person is in dominating position upon the other, dominating position in respect to mental aspect, that is the willingness of the person. And we had seen certain examples. There are several other examples. So that is an active confidence. For example, the teacher is in the dominating position, and the student is in subordinate position. अब suppose you are in dominating position and I am in subordinate position. Suppose, अब मान लो आपने मुझसे कहा कि आप अपना मकान मुझे बेच दो. आपने कहा मुझसे कि आप अपना मकान हमें बेच दो. And I am influenced in subordinate position. मैंने मकान की कीमत मान लो 1.5 करोड़ है और आपने कहा कि इसको 50 लाख में बेच दो हमें. मैंने आपको 50 लाख में बेच दिया. तो इस सिचुएशन में मेरे को तो 1 करोड़ का घाटा हो गया, 1 करोड़ का नुकसान हो गया मुझे. अब द ट्रांजैक्शन इज डन एंड नाउ द कंसिडरेशन इज inadequate. And if you remember the law of contract, the mere inadequacy of contract mere inadequacy of consideration is not going to affect the contract. But suppose if I suggest that there is an undue influence and I want to avoid the contract because there was an undue influence, then in such a case, so undue influence is in section 15 of Indian Contract Act and उसकी wordability is in section 19 of Contract Act. 19A में 19A में wordability 19A में होगा. So let's repeat the example. A has sold his house to R for 50 lakh rupees, 1 crore का नुकसान. Now A refuses to give the house. So R files a suit against A, and in this suit the question is as to whether the transaction was proper or not. And the Contract Act clearly says in section 25 that mere inadequacy of consideration will not renders the contract agreement void. So that rule will apply. But A is saying that there was an undue influence upon me. Now what shall the court do in such a case? Now there is price of list, market price. Now the court will presume under section 111 here that the contract was improper. That is, the person who is in the position of active confidence, he misused his power upon the others and let the burden of proof lie upon him to prove that the contract was not entered into involuntarily. मीन्स कॉन्ट्रैक्ट हमारी रजामंदी से, दोनों की रजामंदी से वॉलेंटरली हुआ था. ये प्रूव करना उसकी जिम्मेदारी हो जाएगी. मान लो मैंने आपसे 50 लाख में आपका मकान खरीद लिया, तो बर्डन मेरे ऊपर होगा कि मैं ये प्रूव करूं कि कॉन्ट्रैक्ट में आपने अपना कंसेंट वॉलेंटरली दिया था. सो दैट प्रिजम्पशन विल गो अगेंस्ट whom? Against the person who is in the dominating capacity. Where there is a question as to the good faith of a transaction, between parties, one of whom stands to the other in a position of active confidence, the burden of proving the good faith of the transaction is on the party who is in a position of active confidence. मतलब अगर आपने कुछ गलत बार्गेन किया है तो ये माना जाएगा कि एक्चुअली आपने मिसयूज किया है अपनी पोजीशन का. अब बर्डन ऑफ प्रूविंग कि नहीं बार्गेन प्रॉपर था और वॉलेंटरली था, ये किसके ऊपर होगा? द पर्सन हु इज इन द एक्टिव कॉन्फिडेंस का पोजीशन. ओके, नाउ सी इलस्ट्रेशन. द गुड फेथ ऑफ अ सेल बाय अ क्लाइंट टू अ अटॉर्नी is in question in a suit brought by the client. The burden of proving the good faith of the transaction is on the attorney because he is in the dominating position. Client और attorney में, attorney means वकील, advocate. तो lawyer और client का भी active confidence हो सकता है. So the burden of proof is upon the lawyer, attorney. Now illustration B. The good faith of a sale by a son just come of age to a father is in question in a suit brought by the son. The burden of proving the good faith of the transaction is on the father. Is upon the father. So इधर father का dominating position है. So let the father prove that he entered into the transaction in a good faith. So that's all. I hope you understand the meaning of the active confidence. अब इसके बाद 111A है, सेक्शन 111A. सेक्शन 111A एक्चुअली जहाँ पर इस तरह के केसेस है जहाँ पर वेजिंग वॉर, नक्सलाइट एक्टिविटीज, इस तरह के एक्टिविटीज जो होते हैं उससे रिलेटेड है. अब सेक्शन ये कहता है कि मान लो पैरामिलिट्री फोर्सेस या गवर्नमेंट फोर्सेस और नक्सलाइट के बीच कहीं पर एक्सचेंज ऑफ फायर हुआ, कहीं पे भी एनीथिंग बिटवीन नक्सलाइट और एनी सच पर्सन. सो ऑन वेजिंग वॉर, तो उनके और गवर्नमेंट फोर्सेस के बीच में एक्सचेंज ऑफ फायर हुआ and some person is arrested on the spot, then there it shall be presumed, अब shall है इधर, it shall be presumed that such person had committed that offense, मतलब वो भी उस ऑफेंस का पार्ट है। अब सोचो कि मान लो एक गांव है, देयर इज अ विलेज, अब उस गांव में कुछ नक्सलाइट्स आए हुए हैं एंड देयर आर विलेजर्स आल्सो एंड सम नक्सलाइट्स आर एंटर्ड इनटू देयर विलेज। अब सीआरपीएफ गॉट द इंफॉर्मेशन एंड दे गो and there is an exchange of fire between the Naxalite and CRPF. अब ये Naxalite तो कुछ तो मारे गए और कुछ भाग गए, but these poor villagers who are found on the spot, now it shall be presumed that they were also a part of the Naxalite. So in this way that is a harsh section. So the court has to look it liberally. अब जहाँ पे भी लगाएंगे, जैसे इसमें Naxalite और आर्म फोर्सेस के बीच में लड़ाई हुई, सीआरपीएफ और नक्सलाइट के बीच, एंड देयर आर सर्टेन इनोसेंट पर्सन्स हु वाज फाउंड ऑन द स्पॉट, बट एज पर दिस सेक्शन दीज पर्सन shall be presumed to be a party to that crime, to that offense, unless the contrary is proved. अब contrary कैसे prove करोगे? You will prove that I am a native of that village, I am native of this village, and I am not committed any wrong. So you can prove it, but the section is harsh. So read it once. Where a person is accused of having committed any offense specified in subsection 2. Specified in subsection 2. What subsection 2 says? The offense related to in subsection 1 are following, namely an offense under section 121, 121A, 122 or 123 of the IPC, criminal conspiracy or attempt to commit or abatement of an offense under 122, 123 of IPC. So waging war, etc. That kind of offenses they are talking about. So any area declared to be a disturbed area under any enactment where a person is accused of having committed any offense specified in subsection 2. Any area declared to be a disturbed area under any enactment for the time being in force, making provisions for the suppression of disorder and restoration and maintenance of public order. कौन सा एरिया जो डिक्लेयर किया गया है? डिस्टर्ब एरिया, एंड फॉर मेकिंग प्रोविजंस ऑफ सप्रेशन ऑफ डिसऑर्डर, डिसऑर्डर को सप्रेस करने के लिए, एंड रिस्टोरेशन एंड मेंटेनेंस ऑफ पब्लिक ऑर्डर, और एनी एरिया इन विच देयर हैज बीन over a period of more than 1 month extensive disturbance of the public peace was there, and it is shown that such person had been at a place in such area at a time when firearms or explosives were used at or from that place to attack or resist the members of any armed forces or the forces charged with the maintenance of a public order acting in the discharge of their duties. It shall be presumed, unless the contrary is shown, that such person has committed such offense. It shall be presumed, unless contrary is shown, that such person has committed such offense. And I already told you that how can you prove the contrary? There are different ways to prove the contrary. अगर किसी विलेज में है तो वो प्रूव कर दे that he was the resident of that village, or maybe prove that he was kidnapped by those persons, and so forth. So that's it for this section and this lecture. Thank you.